Welcome to Lattes and Lattes, the podcast where we blend the world of law and business with a warm cup of information and common sense. I'm your host, Sidney Wheelan, attorney, real estate investor, and business owner. Each week, we'll be your go-to source for legal insights, business advice, and so much more. Whether you're a seasoned professional, an ambitious entrepreneur, or simply someone seeking guidance, we'll have you covered. From navigating the legal landscape to empowering you with valuable business strategies, we'll explore the legal side of life and enjoy a virtual latte along the way. So, grab your favorite latte, get comfortable, and let's dive into Lattes and Lattes. Welcome to episode 7 of Lattes and Lattes. I'm your host, Sidney Wheelan. This episode is sponsored by the Wheelan Law Firm of Moberly, Missouri. Today, we will be discussing the probate of a decedent's estate. As you may be aware, I am a big proponent of avoiding probate if you can. What do you do, though, when you find yourself in the position of dealing with a loved one's death and they did not participate in any estate planning prior to their death? The answer is that you must probate their estate to transfer their property after their death. What does that mean, and how do you start? Well, in this episode, I hope you will learn about the various types of probate procedures to transfer property when a loved one passes. First of all, what is probate anyway? Well, probate is a court-supervised process of transferring legal title from a person who has died, often referred to as the decedent, to the person's distributees or heirs. Probate is necessary to protect the rights to the probate estate of a decedent's heirs, devisees, and creditors. It is the duty of the probate judge to make sure that the I's are dotted and the T's are crossed, and to make sure that creditors are paid if there are sufficient estate assets, and to make sure that there is an orderly transfer of the estate property to the heirs and devisees of the decedent. Before we get started, let me give you a few terms and talk about what these terms mean. First, claim. It's a debt or liability owed by the decedent at the time of death. It could be medical bills, credit cards, the funeral expenses, and the cost and expenses of administering the probate estate. A claimant is the creditor who files a claim against a probate estate. Devisee, it is the person named in a will to receive certain property. This may be a person or an entity, such as a charity. Distributee, a person or entity to receive a distribution through probate. Heir, that's the person determined by the Missouri statute of intestate succession to receive real or personal property of the person who died without a will. Remember, intestate means the decedent died without having a will. Testate means that the decedent did have a will. The document from the probate court appointing the personal representative of an intestate's estate, meaning no will, is called Letters of Administration. It's the court order that allows you to collect the decedent's assets and administer the estate. A similar order, referred to as letters testamentary, is the it's the document from the court appointing the personal representative of a person who died with a will. That person is referred to as the testator, or, if female, the testatrix. The personal representative is a person appointed by the court to be in charge of the decedent's probate estate. He's sometimes called an executor or an administrator. The probate estate, of course, is the real estate and personal property owned by the decedent and is subject to administration supervised by the probate court, including any income after death. Publication is a notice published in the newspaper in the county where the decedent resided. Testate means the decedent who died without leaving a will. Next question, is probate necessary to transfer property at death? Yes. Probate is necessary unless the decedent did not have any property to be transferred at death through probate. So, how could the decedent have avoided probate? I could talk for hours on this subject, but I won't do that here. I will just summarize by saying that a person may take steps with the titles to their property or rules of various agreements to avoid probate while alive. Those things could be giving away property, putting property in a living trust, setting up joint bank accounts with rights of survivorship, creating pay on death or transfer on death beneficiary designations or beneficiary deeds, and naming beneficiaries of life insurance or retirement accounts, such as IRAs. Many of these techniques are described in episodes 1 through 4 of this podcast, and I urge you to check those out when you have a few minutes. So, how does probate work? The decedent's property is held and managed by the personal representative during the administration of the estate. The personal representative makes distribution of the estate when the probate court approves the transactions made to pay claims and expenses and the proposed distribution schedule. The earliest that an estate may be closed and distributed in Missouri is approximately 6 months and 10 days after the date of the first publication. However, it often takes a year or more to finish the administration. The following are steps in the probate process. 1. Hire an attorney to represent you. 2. Apply for letters testamentary if there is a will admitted, or apply for letters of administration without a will. 3. Publish notice to creditors. The date of the first publication starts the 6-month period for claimants to submit their claims to the court and the personal representative. Next, file the inventory and appraise assets. Then administer the estate and sell the property if funds are needed to pay bills. You must remember that you have to get the court's permission and a court order to sell estate property. Next, you must pay the debts, claims, taxes, and expenses of the estate. You must prepare a settlement showing all income and disbursements and obtain court approval for any distribution before you close the estate. So if I'm a creditor of a decedent, how do I go about collecting those debts? Well, the probate court oversees the process by which creditors of the deceased can protect their claims and seek payment. Also, the personal representative can collect payment of any debts owed to the decedent, as well as seek the recovery of any property owned by the deceased that may be in the possession of others. Claims and family allowances against an estate must also be paid by the personal representative before the heirs and devisees can receive their distributions. If there are not sufficient assets to pay all claims and allowances, they are paid in proportion by certain priority classifications set out by statute. For example, the funeral bill is a high priority item and must be paid before general claims. So, what about taxes payable after death? An important function of probate is to assure payment of any tax liability. A probate estate must have a federal tax ID number called an Employer Identification Number, or EIN. A fiduciary income tax return may have to be filed for the estate. The fiscal year for tax purposes can start with the decedent's date of death. The administration of the estate normally may not be closed until taxes, both state and federal, have been paid, including death transfer taxes, if any. The decedent's final income taxes, estate income taxes, and real estate and personal property taxes must be paid. Death transfer taxes must be paid on any probate assets and other assets transferred at death, for example, life insurance, only if those amounts are over a certain minimum. And that amount is subject to change by Congress each year. Expenses of probate. The administration of any probate estate involves the payment of certain expenses. Those expenses are usually encountered in the average estate and fall into four main categories. 1. Bond premiums. The probate estate may have to pay for a bond for the personal representative to guarantee the proper handling of the estate. All distributees of the estate or the decedent in the will may waive the necessity of bond if the court allows it. 2. The cost of publication. A notice to creditors must be published announcing that the estate has been opened. A notice of intention to file a final settlement or statement of account must also be published before the estate can be closed, again, unless it is waived in writing by the distributees of the estate. 3. Court cost. Every estate must pay cost based upon the size of the estate being administered and the services the court is called upon to provide for the estate. 4. The personal representative's fee and attorney's fees. In Missouri, the statutes provide for a minimum fee schedule for each, the personal representative and the attorney's fees. Compensation in excess of the scheduled fee may be paid upon court order or upon consent of all the distributees. The minimum scheduled fees are based upon a percentage of the amount of money and personal property administered in the estate. This percentage is based upon a graduated scale as follows: 5% of the first $5,000, 4% of the next $20,000, 3% of the next $75,000, 2.75% of the next $300,000, 2.5% of the next $600,000, and 2% of everything more than $1 million. So I know that's a little complex. For example, an estate in which $110,000 is administered would generate a personal representative fee of $3,575 and also the same fee for the attorney's fees. Both fees combine to be 6.5% of the estate. There are particular rules in the probate statutes in Missouri to establish title to real estate through a probate estate. The administration of a decedent's probate estate serves to establish clear title to any real estate in which the deceased may have owned at the time of death. Real property passes directly to one's heirs or to one's devisees if a will is admitted to probate. The personal representative will have to obtain a court order to take possession of or sell the real estate unless the will specifically gives the personal representative that authority. It does not technically form a part of the probate estate unless it is necessary to sell the property to pay debts or for other reasons as set out in Missouri law. It is impossible for the heirs or devisees to sell or receive clear title to the property subject to probate for 1 year after death unless it goes through probate. In Missouri, probate may be opened and administered, and a will may be filed within 1 year after the decedent's death. Similarly, creditors may take actions to enforce claims which could force the sale of real property within a year of the date of death. However, if an estate is probated, the period of time in which title to the real property can be so effected is reduced to approximately 6 months after the first publication of letters. If there is no will, the surviving spouse in Missouri has certain rights. In Missouri, the spouse of a decedent is entitled to receive 1/2 of the estate of an intestate decedent. Remember, intestate means that a person died without a will. If the decedent is survived by children and the spouse of an intestate estate, and if the spouse is also a parent of those children, the spouse receives the first $20,000 and then 1/2 of the remaining assets of the estate. This is in addition to certain exempt property and other statutory allowances for the spouse. Exempt property is that which the spouse or unmarried minor children are entitled to receive absolutely, without regard to any provisions the deceased might have made for the disposition of other assets. The exempt property includes the family Bible, books, clothing, household appliances, furniture, one automobile, and the like. The support allowance is another award made to the surviving spouse for his or her maintenance and maintenance of any unmarried minor children for a period of 1 year after the decedent's death. The amount of the award is judged by the family's previous standard of living. Now, the surviving spouse's rights if there is a will. If the decedent leaves a will giving the spouse less than the spousal share, the spouse may, within a limited time, elect to, quote, take against the will, close quote. The spouse can then receive the statutory share rather than what was provided in the will. The probate court is required to notify the surviving spouse of this right of election shortly after the will is probated. A spouse cannot be completely disinherited under a will unless some form of contractual arrangement is made. This could be a prenuptial or postnuptial agreement. A spouse is entitled to receive either 1/2 of the deceased property if there are no children or grandchildren of the decedent, or 1/3 of the property if the decedent was survived by children or grandchildren. This election for a spousal distribution is subject to the claims of creditors and estate expenses, and is in addition to the survivor's statutory allowances and exempt property. Other property received by the surviving spouse outside of probate from the decedent, such as life insurance, joint property, and trust assets, serves to offset against the spousal share. Omitted spouses, or those who were married after the deceased will was executed, may claim an intestate share of the estate. In certain cases, similar provisions are also included for any children who might have been born after the will was executed. Let's talk about a couple of other types of probate administration. There are 2 types of probate administration permitted by Missouri probate law, both supervised or independent. A supervised administration is closely monitored by the probate court. The court must approve many actions of the personal representatives, who must also file annual settlements that are fully reviewed and audited by the probate division. Independent administration is more informal and eliminates the need for supervision by the probate division and eliminates annual settlements. An estate may be independently administered if so designated in the deceased will, or if the distributees all agree. If a decedent's estate is valued less than $40,000, you have some additional options. A small estate certificate may be obtained 30 days after the decedent's death by a distributee without going through the full probate process. The distributee, called an affiant, must file an affidavit promising to use the decedent's assets to pay debts and distribute the property according to law. If the total value of the assets of a decedent that must go through probate is under $15,000, no publication is even required, and it is a relatively simple and quick process. If the value of the decedent's assets is somewhere between $15,000 and $40,000, publication is required for 2 weeks. Surviving spouses and the decedent's minor children can file what are called refusal of letters to have their statutory allowances paid from a decedent's estate if the estate is valued at a lesser amount than the allowances. Creditors can also reach certain assets, such as bank accounts, to pay their bills by filing creditor refusals of letters if the estate value does not exceed $15,000. Remember, in Missouri, you only have 1 year from the date of death to open a probate estate. If it is determined that the decedent did have assets after the 1 year has expired, another type of process may be filed called a determination of heirship proceeding. A petition may be filed to obtain a judgment determining the heirship. Another alternative is an affidavit of heirship if there's only real estate, and if it is acceptable to the title company that would be insuring the title to that real estate. So, do I need an attorney in a probate process? The short answer is yes, when a regular decedent's probate is undertaken. Again, as you have probably heard me say before, this is not a do-it-yourself project. An attorney is required to represent the personal representative in both supervised and independent administrations in Missouri. A lawyer can assure that all deadlines are met and avoid mistakes and delays. A lawyer can sometimes help explain the process to family members to prevent disagreements among them over various issues. Some people may file a small estate affidavit and letters of refusal for spouses, minor children, or creditors without attorneys. But using an attorney can avoid costly mistakes, especially if real estate is involved. You should find an attorney who practices probate law. In this episode, we have explored the various types of probate estates. As you can see, depending upon the value of the assets that must be administered by the probate court, the cost and complexity of administering a probate estate can vary greatly in cost and time. With proper planning before you die, you can spare your loved ones the necessity of navigating the probate process. I hope that you will seek out competent legal advice, not only if you find yourself handling a decedent's estate for a family member, but to try to avoid the process for your loved ones at your death. I hope that you have found this episode helpful. As a reminder, if you hit the subscribe button, you will automatically be alerted when a new episode airs. If you enjoyed this episode, please give us a 5-star review and share it with your family and friends. As always, my friends, grab a cup of coffee or your favorite latte, hold your loved ones tight, and have a great week.
This podcast episode contains general information for discussion purposes only. Each case is different and must be judged on its own merits. Missouri rules generally prohibit lawyers from advertising that they specialize in particular areas of the law. This show should not be construed to suggest such specialization. Nothing on this show should be taken as legal advice for any individual case or situation. This information is not intended to create an attorney-client relationship, and the listening or viewing of this podcast does not constitute an attorney-client relationship. The choice of a lawyer is an important decision and should not be based solely upon advertisements.